Hello, everyone. Hello, Internet. My name is Tom Grieve. I'm a former state prosecutor, criminal defense attorney. Today, we're going to be talking about the two big decisions that have come out of one out of New York, the other one out of Texas, both going the opposite direction from one another. So we have one pro FRT, one against FRT. I'm going to break the whole thing down. This is not going to be a discussion of Brune. This is not going to be a discussion of Second Amendment and kind of broad battle lines on that kind of scale. If you came here expecting that, that's not what this is. That's not really the way how law often works. In order to win things, we've got to instead, rather than doing the frontal attack on the Brune decision, we've kind of do a flank attack, and that's what we're going to be getting into here. Here's the super low resolution version of this in case you only have a couple minutes. We've got the two decisions, as we mentioned, one from Texas, one from New York. Guess which one went which way? The New York judge basically issued an injunction against Rare Breed. That's, of course, the company manufacturing the FRT WT triggers, prohibiting them from selling FRTs, as well as forcing them to maintain their business records of everyone that they're selling them to, okay? As well as any other existing records of people who they have already sold them to. Now, that lawsuit comes out of a filing by the DOJ back in January of 2023, where the DOJ is basically alleging that, look, they're committing mail fraud, wire fraud, all that other kind of stuff. More of those details later on. The super short version of the Texas case, we have some different plaintiffs that are suing, and the judge in Texas issued an injunction against the ATF and the DOJ and the government writ large, and enjoined them against enforcing both civil as well as criminal penalties, but only as it applies to those plaintiffs. So at the end of this video, if you stick around, and I hope that you do, your options are not going to change. And I don't want people to think that there's some sort of clickbaitiness to this. I'm going to be explaining these decisions. We're going to be going into some level of detail on them, but fundamentally, nothing about your options has changed. So let's just get that out of the way up front. And by the way, as far as what those options are, because here in Wisconsin, I get these phone calls constantly, really quickly. I always ask people, it really depends on what your value hierarchy is. If your value hierarchy is Second Amendment first, then presumably you're going to want to fight. And if you want to fight, then you want to keep your devices, basically ride out the storm. And those folks are basically going to see how the world looks on the other side of that. We've got a number of different lawsuits going on this. Who knows where this is all going to be going? Hopefully in a good direction. But again, just who knows, just to be honest and upfront with you. Of course, you're going to reassess along the way as needed. Now, the downside is you risk incarceration, you risk felonies, you risk prison. But alternatively, you do more than risk caving to the ATF. That is your decision to make. On the other side of fights, we have basically flights. And this is where your highest value in your hierarchy is to protect yourself. So this means that you are probably considering destruction of your device or devices. And basically, I always tell people, don't make a record of anything about when you destroyed it, because it is, if the ATF wins this, it is going to be a legal machine gun up until the moment that you destroyed it, beyond the point of reassembly, which means that if you make a record of when you destroyed it, you've simultaneously made a record of when you have possessed it up until. So keep that in mind. It's like a tracer bullet. That thing goes both ways if you record exactly when you destroyed it. All right. So here late in 2023, we're getting on in the game. It's no longer kind of the opening salvo from the ATF. I'll be going through this procedural history in a moment. But you could be facing a highly aggressive prosecution at some point in the future who could be using your timestamps when you destroyed it against you. Of course, then there's also the consideration of, do you then turn it in? Do you contact a knowledgeable attorney to help you with that? Do you go about it yourself? There's pros and cons to all that. I'm not going to bore you here with that. As you mentioned, here in Wisconsin, I actually handle a lot of these kind of phone calls, and I spoke to one gentleman about that exact situation today. The gist to it is there's lots of variables, too much to get into here. If people want, let me know. After this video goes live, the YouTube comment section will populate, and then drop some comments in there. Once actually the video wraps, I should say. So there it is. That's the short version. Now, for those of you who want to know how the engine works and where this thing is going, let's get into it. So we've got two cases that were released approximately 3 business days apart. One from a Bush appointee in Texas and the other from a Biden appointee in New York, with nearly as predictable outcomes. The New York decision comes from the case of U.S.A. versus Rare Breed Triggers, LLC. The Texas case is the National Association for Gun Rights, Incorporated versus Garland. And these two courts, as already mentioned, went in basically opposite directions while each of these cases are different. One of them was filed by the government in New York against Rare Breed, alleging fraud and seeking injunctions to basically shut down their business and preserve their record. And the one in Texas was filed by basically the plaintiffs, that is, are people who possess the Rare Breed triggers, possess the FRTs, who are seeking a bar on enforcement against it. A lot of these are going to be hinging on the exact same question. Even though we're talking about a lot of different laws, they're going to be hinging on fundamentally some exact same questions. And you already know what that is, whether or not these are going to be actually considered machine guns. So what the heck's going on here? Let's do a quick recap. And yes, the details are going to be relevant. So I'm going to breeze through this really quickly. A lot of this I've already put in the description box below. I'll be adding more to this after the video goes live on being published. So an FRT trigger. In my past videos, I assumed everybody knew, and I kept seeing comments saying, please summarize what this is. FRT stands for Forced Reset Trigger. This is a semi-automatic assembly that allows the trigger to reset basically more quickly than it otherwise would using a traditional trigger return spring. This assembly enables the user to fire the firearm at a quicker rate than a traditional trigger. An FRT is a device that forcibly returns the trigger to its reset state. So FRTs are designed to achieve this by hammer resetting the trigger when the bolt carrier cycles to the rear. This is called a locking bar, mechanically locks the trigger into its reset state, preventing the user from moving the trigger rearward to function by release of the hammer until the bolt is returned into the battery position and the firearm isn't safe to fire. So the gist to it, and again, all these details I'll throw in the description field below after the video goes live, is that it can simulate full automatic fire. But I need to stress the fact that this is simulated full automatic fire without it being automatic fire. Kind of like how I can simulate being a pro golfer on the weekend by hitting a ball with a club, even though there is a world of difference, both physically and importantly, legally. I am not a member of the PGA. And those two important distinctions are going to be the critical key distinctions that we're going to be talking about here. Now, you're going to see the definition of a machine gun from 18 U.S.C. 922 sub O sub 1 down in the description box below. I'm going to read the relevant parts. A machine gun is defined by the NFA as any weapon which shoots automatically more than one shot by single function of the trigger. Single function of the trigger. That's the relevant part here, folks. So how did these two judges wind up with two very different rulings when we're looking at fundamentally some of the very similar underlying issues? All right, now we've covered that ground. So ATF has entered the chat. For decades, ATF regulations importantly have mirrored the federal statutory definition of what is a machine gun. That's just what I read to you, single function of the trigger. Now that changed with the ATF when they changed their regulations in 2018. Now notice I changed their regulations, the ATF did. I didn't change the regulations. That'd be great if I could, but I did not. The ATF did not change the statutes. Of course, the ATF lacks the ability to make law. They are allowed to interpret law up to a point. We're going to be getting into the Administrative Procedures Act in a moment, but they cannot make law. Here's the section that they added, quote, for purposes of this definition, the term automatically as it modifies shoots is designed to shoot or can be readily restored to shoot means functioning as the result of a self-acting or self-regulating mechanism that allows the firing of multiple rounds through a single function of the trigger. And single function of the trigger means, here's the important part, a single pull of the trigger and analogous motions. The term machine gun includes a bump stock device, a device that allows a semi-automatic firearm to shoot more than one shot with a single pull of the trigger by harnessing the recoil energy of the semi-automatic firearm to which it is affixed so that the trigger resets and continues firing without additional physical manipulation of the trigger by the shooter, end quote. That's pretty handy when the ATF can basically expand and change and basically move the goalpost from single function of the trigger to single pull of the trigger. And you can probably already see where this is going. Let's cover some administrative stuff here. And yes, this is interesting because these questions come up all the time. Now, again, all this is in the description box. So 3 years after the ATF broadened this interpretation in 2018 of the statutory definition, two of the ATF's divisions actually issued reports regarding FRTs. This came from the Firearms Technology Criminal Branch, the FTCB, Firearms Technology Criminal Branch, which issued its technical examination report on July 15th of 2021, which purportedly classified the FRT 15 trigger as a version, by the way, it's a version of the FRT, as a machine gun. The FTCB issued a similar report several months later on October 21st of 2021 regarding the wide open enterprises. That's the WOT version of the FRT. At the beginning of the next year, we're now in 2022, the FTCB issued its, quote, open letter to all federal firearms licensees, end quote, on March 22nd, 2022, advising that ATF, quote, recently examined devices commonly known as force reset triggers, and it's determined that some of them are firearms and machine guns as defined by the Gun Control Act, National Firearms Act, all that kind of stuff, end quote. Most importantly for these lawsuits, again, both the one in New York as one in Texas, the open letter further explained that the ATF's examination found that, quote, some FRT devices allow a firearm to automatically expel more than one shot with a single continuous pull of the trigger, end quote, and that any FRT that allows a firearm to automatically expel more than one shot with a single continuous pull of the trigger is a machine gun. Of course, 1 month later after that, the ATF Firearm and Ammunition Technology Division issued yet another report basically saying more or less the same thing. So there you go. There's the fun background. We've now set up the landscape. We've set up our dominoes. Now let's tap them over and we see exactly where this is going. FRT is saying, look, this is not a single, it's more than a single function of the trigger. That's how our device is made. That's how this looks on the inside, which is, by the way, how it's regulated under statute. That's important because statute, that's what Congress passes. Now, the antis are, of course, using, you know what I'm going to say, they're using the expanded 2018 ATF definition, where they moved the goalposts from single function of the trigger to single pull of the trigger. Now, this reminds me, if we go back to another video I did with actually an inventor, if you go back, he invented the Atkins device, which was basically the precursor to the bump stock. And back in, I think it was 2008, I'm sure the internet will fact check me on this, but off the top of my head, I think it was 2008, where he got into a lawsuit with the ATF where they were trying to shut him down on his device. And in court, they were arguing single pull of the trigger. Even, of course, back then, they didn't even have the expanded ATF definition, which would come about a decade later, as far as the single pull of the trigger versus single function of the trigger. And this is the reason why this kind of stuff, for those of you who have stayed along through how kind of things work down here in the boiler room of courts, that's why this is so important. Because what they're using in the legal arguments today in 2023, they're going to be using that and encoding that into ATF and other regulations into law, in essence, operative law, not actual law, but operative law in the sense that you can go to prison for it. The legal arguments today turn into operative law tomorrow. All this stuff is super important because they're all tipping their hand. They're all tipping their hand on where things are going here. So we've got the different goalposts, and now how did this all play out? Well, ready to meet our old friend from the pistol brace discussions, the Administrative Procedures Act, the APA. Now, the APA is basically the governing law about how regulatory bodies, and as you recall, there's hundreds of regulatory bodies, the Environmental Protection Agency, of course, the Internal Revenue Service, it goes on and on and on. Here we're talking about the ATF. The APA instructs them on how they are allowed and how courts are to interpret when the ATF, one of these bodies, tries to basically move their interpretations of law. How is a court to step in on that? When is a court basically allowed to throw the referee flag and say, you know what, you've kind of overexpanded. You've gone beyond the statutory authority of what's being said, because Congress will pass a law and they'll create the statutory authority. And then if the agencies go beyond that authority, they're supposed to be slapped back inside that authority. But keep in mind, why do they have this in the first place? And this is not to defend it. This is simply to explain it, because there are way too many different issues and specific instances of trying to figure out if you've got a ball versus a strike, and Congress cannot address every single instance. So the way that our system works, for better or worse, is that the Congress and the executive branch, depending on what we're talking about, has delegated authority, generally the executive branch though, has delegated authority to all these different government agencies to basically say, okay, here in this particular case, Congress spoke to these principles. So maybe their line goes like this, this. We're going to draw the line that goes them like that. So the statute here, we're going to create a line between them that is consistent. But they can't jump the line necessarily. They may be able to push it, and they definitely can't move the statute. They lack the authority to do that. And that's basically what the Texas judge said that they did here. Okay. You cannot act in an arbitrary and capricious expansion of an agency's authority. Because FRTs do not enable a weapon to automatically fire multiple rounds with a single function of the trigger itself, the Texas court finds that FRTs most likely are not machine guns under the Fifth Circuit's Cargill's reasoning. That's Cargill v. Garland. That's a case that we were talking about when we're talking about bump stocks. We did a video on that. After this video gets published and wrapped up, I'll be sure to link that in the top pinned comment. So be sure to check out our video on that. Because again, all these things are always building on each other. Here you see the FRT decision building on the bump stock decision. So this all fits together, guys. And there is nowhere, and I enjoyed reading this in the case in Texas, there is nowhere that the Texas judge left for the ATF to really run and hide, legally speaking. Direct quote from the case. When the ATF revised its definition of machine gun to state that, quote, a single function of the trigger, end quote, is the same thing as a, quote, single pull of the trigger and analogous motion, end quote, its definition conflicts with the definition provided by statute. So you got to understand that the procedural footwork of this, these are not conclusive. The case is now done. The way that these cases often go is that they get filed in court. Both sides basically look for summary judgments to saying, look, we win this in a slam dunk. We don't have to go through discovery. We don't have to go through everything. And they also seek what's called preliminary injunctions, basically trying to shut down the other side. So not always the case, but often the case that so goes the preliminary injunctions, so goes the lawsuit. So here in Texas, so went the preliminary injunction in favor, at least for now, and we're going to get to that in a second, in favor of the plaintiffs. Hopefully, that's also tipping the hand likely of where this is going to be going by the end of the day. And by the end of the day, the judge did give up until September 27th in order to basically kind of finalize and look more into this. So this is, so to speak, a preliminary temporary injunction, if you want to use that terminology. And then typically what happens is the losing side will appeal it. So down in Texas, they would be appealing up to the Fifth Circuit Court of Appeals. That's the court that fits between the federal district court, that's the trial court in federal law, and then the circuit courts, okay? That's the courts of appeals. So they usually tend to have anywhere from 2 or usually about 3 to 7 states each or something like that. So we're in Texas is in the fifth, that's based out of Louisiana. Okay. And then the next court above that, now we're talking U.S. Supreme Court. Okay. So they gave until September 27th, basically for the judge to kind of amend things and look things on. But I cannot stress enough that this only functions to those particular plaintiffs. So this is not like the pistol brace rules, where if you're a member of an organization, then maybe depending upon how you feel about that, you're going to be covered or good to go. It's not what we're talking about here. It very specifically only applied to the plaintiffs in the case. Okay, so that's what Texas is up to. What is New York up to? So the first case was brought by the government, and that's the rare breed. That's USA versus rare breed, to basically stop the company from selling the triggers as well as to gain access to their customer records. There were allegations that basically the rare breed company, in order to protect their customers, were destroying and hiding business records so that basically the ATF could not use those to go and prosecute people. In a nutshell, that's the gist to it. The case is actually really interesting. It's 129 pages, but they really go through a lot of this kind of stuff. That's because that case is a lot more engaged with issues of fraud. So again, a little bit different. And by the way, the fraud parts that deals with basically so-called mail fraud as well as wire fraud, which in essence goes back to if you're selling something that's illegal, when you take the payment, that's wire fraud. And then when you mail out the device or the product, whatever it is, that's the mail fraud part. Oversimplification, but pretty accurate at the same time. So that's what the government's alleging. They're saying that the company Rare Breed is knowingly and intentionally misleading customers about the legal status of their product, taking payment and doing all that kind of stuff. So as I already mentioned, this was filed back in January 2023, so about 9 months ago now, a little under 9 months ago. And that's what they're trying to do with it. That's what the government's trying to do with that. And what they're going to be doing, of course, with the records, once they get them, is so-called enforcement actions, which, of course, is code for prison. So the judge in that 129-page decision stated in their preliminary injunction, again, that's the stage of the case we're at in both cases, the preliminary injunction, this is the New York judge now, that Rare Breed defrauded customers by saying that its FRT 15 triggers were, quote, absolutely legal, despite having failed to win Bureau of Alcohol, Tobacco, Firearms, and Explosives approval for their sale. Quote, the court concludes that the government is likely to succeed on the merits of its claims, and this is coming from, end quote, by the way, U.S. District Court Judge Nina Morrison. And she went on to add that the company has placed tens of thousands of their customers at risk of criminal prosecution, as well as their loss of right to own firearms, end quote. So that's basically the gist to what's going on there. The judge didn't really even look at the issue of, well, in 2018, they moved the needle. She basically just took that as baked into the pie. Whereas the Texas judge teased those two things apart and said, look, this is kind of a misstep here. That's the gist to this, okay? The judge in New York observes, quote, like the trigger on a standard semi-automatic weapon, the internal portion of the trigger on an AR-15 outfitted with the FRT-15 releases the hammer with each successive shot. Like a machine gun, however, the shooter need only pull the FRT-15 trigger once and maintain rearward pressure for the gun to rapidly fire multiple rounds, requiring no additional input from the shooter. In a cycle of fire, the FRT-15, like a standard machine gun, fires each shot in 1/10 to 1/14 of the second, end quote. Guys, just what this reminds me of is whether you want to use the self-deprecating analogy of me definitely not being a professional golfer, even if I don't even look like a professional golfer. We'll use a different one. Electrical cars, right? If you don't know anything about cars, if you just saw an electrical car on the road, full on electric car, as well as a gas car, they look kind of the same. They function kind of the same. But when the laws about whether or not a car is legal or not go to, does it run on gas or does it not run on gas? The fact that the electrical car may look like a gas car, but it doesn't run on gas, that's a big deal here. And that's fundamentally what we're talking about here. Are we going to classify things on the basis of what they look like and how we feel about that look? Because in essence, that's where not only the anti-gun crowd is trying to go with everything, of course, all the time, but that's where the ATF is now trying to enact that into their regulatory powers. And of course, that's where the judge seizes on that and goes here. Whereas on the pro-firearm side, the pro-Second Amendment side, that's where we are seeing the fact that, no, look, the law functions on how this thing works, not how it looks. It goes by how it works. And when we go on that basis, FRT is not a machine gun. And there you have it. Our quote of the day, for those of you who stuck around, comes from the Greek philosopher Heraclitus, quote, no man ever steps in the same river twice, for it's not the same river, and he's not the same man. We appreciate you sticking around. I look forward to reading your comments in the actual upload of this video. So not like the little chatty comments, which I'm also going to breeze through, but give me some feedback about what you liked, what you didn't like, what you want to see more of and follow up on. If you want to see me examine these fraud issues, if you want to see me do a video expanding the importance of the different options that, frankly, you down the lens have when it comes to what to do with whether it's FRTs, your pistol braces, and so forth. If you want to see me throw basically a big video together about what I'm seeing out there, let me know. Love to see it. Love to see you in the comment section. Thanks very much. We'll see you next time.